Hello, welcome to the second in a brief web chat about disposals in administration. We did one last week, posted on the 1st of March. It's on YouTube and the Wilberforce web channel and things like that, in relation to these new-ish provisions dealing with disposals by an administrator in the first 8 weeks of the administration to a connected purchaser. We looked at connected purchaser in the previous web chat. There are some slides which I will repeat those because they're the same slides. So they're available up there or down there or something like that. So it's me, David Pollard, and Tom Robinson from Wilberforce, talking about the various bits and bobs of the new legislation. We're mainly focusing on who is connected, who is independent, and these particular technical definitions that are there, not least because I wrote a book on connected and associated, which deals with this in more detail than you probably want. This is under paragraph 60A of Schedule B1 to the Insolvency Act 1986 and the Administration Restrictions on Disposal, etc. to Connected Persons Regulations 2021. So we're looking at this in the second go, the issue on the evaluator. So Tom, can you tell us what these regulations repeat?
Yes.
We do what we did on the regulations last time.
Yes, if you've not recently looked at or watched the 1st of March version, then here is a snappy summary of what the new regs do. So they apply to administrations commencing on or after the 30th of April 2021. And what they do is impose a new requirement on administrators who seek to dispose, hire out, or sell all or a substantial part of a company's property to one or more connected persons. And we're going to call this a disposal. A disposal in the first 8 weeks of the administration falls within the scope of the new regs. And we looked last time at the definition of connected persons to identify when a disposal was going to fall within these regs because it was to a connected person. Today we're looking at one of the ways in which the administrator can meet this new requirement, which is getting an evaluator's report. And as David says, there is some technical definition work needed to be done to identify when an evaluator is connected and therefore out of scope. Worth noting at this stage, though, that SIP 16 and SIP 13 continue to apply, obviously. I think there's been a revised SIP 16, in fact, but SIP 16 and SIP 13 are the ones that deal with, firstly, pre-pack sales in administration. That's SIP 16. And they're going to apply even if the pre-pack sale is later than 8 weeks, and even if the purchaser is not connected. So that's one thing to bear in mind. SIP 13 applies to disposals of assets to connected parties in an insolvency process. It's not just administration. So again, that's worth bearing in mind. But these new regs from the 30th of April 2021 impose the new requirement on administrators. And there needs to be either advanced creditor approval for the disposal, or the connected person, the purchaser, needs to obtain a report from an evaluator. The advanced creditor approval route, I think, is going to be unlikely in practice because of the time it's going to take. Either the administrator has to put the disposal in the statement of proposals under para 49, get approval that way, or obtain specific creditor approval to it, which is Reg 4. But assume that that's not practical in the time that you've got, then it's the second route, which is the connected purchaser obtains the report from an evaluator. So think about the pre-pack pool, think about that way of working, but then focus on the idea that there is an obligation on the connected purchaser to obtain a report from an evaluator. And what we're looking at today is, well, who can be an evaluator? In a nutshell, it's an independent person with relevant knowledge and experience and insurance in place, and their role is to give an opinion on whether the consideration and grounds for the disposal are reasonable in the circumstances. Other tricky points on this these regs, what are the consequences of breaching them? That's one. I did a note which is on the Chambers website, 30th of April last year, having a think about some of those. But as I say, today's talk is just looking at evaluators. David, over to you, I think, on the first question of who can be an evaluator.
Yeah, so we looked last time at who's a connected person, and that's a specific definition which looks pretty similar to the connected and associated, or uses in some ways the connected associated test, but it's subtly different in the usual tests in section 249 and section 485. But for an evaluator, if there's a connected person, then the administrator has to check whether or not it thinks that does the administrator have any reason to believe that the individual did not meet the requirements to be an evaluator. So the evaluator's got to be an individual, the administrator's got to do some sort of check, has no reason to believe, is that subjective, is that objective? It's not clear. It's probably a duty of care on the administrator to at least ask the evaluator or ask the connected person, can you confirm that they're not connected, which is quite a difficult test. So they're looking at a number of tests in regs 12 and 13 dealing with independence and all sorts of other things. They're not connected with the insolvency company, that's the 249 definition, not an associate of the connected person, the purchaser, the bidco in our scenario, not connected with the bidco, has a conflict of interest and that sort of stuff. And more specifically, not connected with a company with which the administrator is connected. So that's a bit of a wider test, and it's looking at these 249, 435 definitions on connected and associated, looking at the individual who's the evaluator and looking at are they connected through some other test in that sense. So Tom, what about that lim H there?
Yes, I think the first thing to say is that once you've got to this stage of identifying that there is a connected purchaser, you'll have had to get your head around the fact that there is a different definition of connected for para 60A purposes to identify whether the purchaser is connected to the classic section 249 definition of connected. So you'll be sort of familiar with the idea that, and this is what we covered last week, that there is a definition of connected for the purposes of identifying the purchaser. Well, now when you turn to the evaluator, you've got to put all that to one side and go back to 249 and identify, right, using those tools, using the 249 test, is the prospective evaluator either connected with the selling company, the insolvent company, or connected with the purchasing company, which David's called bidco, or, and this is where it gets more complicated, connected with a company with which the administrator is connected. And given the breadth of 249 and the ways in which you can fall within the definition of a connected party under 249, that's not going to be very easy. The prospective evaluator and the administrator might have to produce lists of the companies with which they are connected. And although it's a present tense, so connected at that time, connected with a company with which the administrator is connected, the pool is pretty wide to identify all those companies with which you're connected using the classic 249 tests, directors, officers, that sort of thing, for which can I recommend David's book on connected and associated insolvency and pensions law, 2021. So it's a broad test, and we think particularly this limb of identifying the connections to companies the administrator is connected with, leave aside connections to the selling company and the purchasing company, is going to be potentially time-consuming and quite tricky.
So both the evaluator and the administrator are individuals. So it's a question of who are they? They're going to be connected with a company if they're an associate of a director of the company or an officer of the company or a shadow director of that company. So you're connected with all the companies where one of your relatives or associates is a director. So I don't know who my uncles and aunts, spouses or former spouses, what companies they're directors of, if any. So actually I would not find it, it would be very difficult, I think it would be difficult for anyone to write down a list of companies with which they're connected. It's just too wide a class. It's much too vague in 249 and the associate definition in 435 and working out who's a director of something. So I think this is actually sort of out there as a potential problem. How do you work out who an evaluator is, who they're connected with?
I suppose you've got administrators sort of quite familiar at identifying before they take appointments potential relationships with the company they're taking an appointment over. So there's a sort of mindset from the administrator side of identifying potential connected parties. But this is going a lot wider to identify the sort of crossover between evaluator connections, prospective evaluator connections, and prospective administrator connections. And as I say, it's not just looking at the insolvent company or indeed the bidding company. It's looking at actually what other companies might I be connected with? And as David says,
when I went back to look at the origin of this connected and associated expressions now in the 86 Act, they're originally in the 85 Act, and they were originally in relation to who could insolvency practitioners take an appointment over. They weren't allowed to take an appointment over a company with which they were connected or associated. And that was dropped and changed by the government in what became the 85 Act, because people stood up and said, well, I don't know if my uncle's former wife is connected with this company or something like that. So it was thought to be too difficult then, but it's sort of coming back through in this evaluator test which could be a problem. So it's going to be an issue for administrators and purchasers. Have I chosen the right evaluator? Unless the evaluator's got no relatives or no other interests or something like that, I don't know. That might be more difficult to find.
Well, I had a case actually. I mean, I wasn't sure whether these regs were going to make a difference in practice or what sort of difference they'd make. But I had a case a few months ago where one prospective purchaser was clearly connected, another one wasn't. And the administrator said, well, the time it's going to take you, connected purchaser, to go through the stages of getting your evaluator's report, identifying the evaluator, and so on and so forth, we just don't have time for that. And so before things had even got off the ground, that potential purchaser was just sort of pushed to the side. And so it did make a real difference as to the pool of prospective purchasers.
I'm thinking you can naively say, well, why don't wait 8 weeks or sign the contract conditional?
Yeah.
But I think signing a contract runs a risk of falling within the disposal.
That's probably the disposal, I would have thought.
Probably disposal of the contract.
I mean, you could do some things by just creating a new bidco, limits the number of potential connections that way, but it's not an answer. So we do think in summary, or at least I think in summary, that there are a lot of prohibited connections that might come out of the woodwork here and spring out of the unknown. And one could well find breaches of these regs, even if inadvertent and even if you take reasonable care. Does slightly beg the question of what the consequence of a breach of the regs, because there's nothing in the regs saying what the consequence is of breaching them. Could the transaction be set aside? I think that's very unlikely. Probably the idea is the administrator, and the obligation is on the administrator to comply with these new requirements, could find some form of misfeasance claim being brought against him. So it's some action against the administrator, I suspect. But all of this, it seems to me, points towards getting the evaluator's report if there's any doubt about it, and you do want to proceed with that purchaser.
Yeah, so there you go. Good. No, well, interesting area.
Thank you. Yeah.
Thank you very much for watching.